United States versus Kelly, 19 CR 286 AMD. Dear Judge Donnelly, undersigned counsel writes to respectfully request a 60-day extension of time in which to file Mr. Kelly's post-trial motions in the above-captioned matter. The government does not object to this request. Although undersigned counsel recently had an opportunity to meet with Mr. Kelly at the MDC, until this week she was unable to conduct even a cursory review of the trial record on account of other professional obligations. As such, undersigned counsel was not formally retained in this matter until just yesterday. Undersigned counsel has been retained to file post-trial motions in this matter and represent Mr. Kelly on direct appeal should this court deny his post-trial motions. As this court is aware, defendant's trial was lengthy, consisting of roughly 25 days of testimony and/or argument. Indeed, undersigned counsel cannot presently confirm that she is in possession of the complete trial record. Undersigned counsel requires an adequate amount of time to scrutinize the docket, read the pleadings and report of proceedings, and study this court's prior orders in the case. To competently represent Mr. Kelly post-trial, undersigned counsel respectfully requests an enlargement of 60 days until December 31, 2021 in which to file his post-trial motions. Respectfully submitted as Jennifer Bonjean, CC, Asa Elizabeth Agetis via ECF. Case 1-19 CR 00286 AMD Document 254 filed October 29, 21 page 1 of 1 page ID number.
What's going on, everybody? How you be? Welcome to the channel. This is your girl, Texas Black Diamond, and you already know, if you already subscribed, this is Texas Black Diamond ENT. So we got information about Miss Jennifer, right? And everybody know Miss Jennifer Bonjean. She is the attorney for Bill Cosby. She represented Bill Cosby and this wrongful conviction trial that he had. She spoke before the justice and she did a great job. So I want to take you back on a video that I did about Jennifer, what she did, how she did it, how prepared she was to answer every question from the each justice. She did a great job. And that's why when we were watching it, I said, this lady is going to get Bill Cosby off because she was well prepared. And so I believe in the letter, she's trying to get more time so she can go over everything for this. And she's also a civil rights attorney. She does a great job. She has a great resume. So I'm go ahead and share it, and I'll let y'all look at that. I hope everybody is having a great weekend. My week is just starting, so it's not a weekend for me. I got to get back to work. Before I play the video, I want to tell you guys, when I went to speak to all these different attorneys, and I also want to give a shout out to Denver. I want to give a shout out to Arizona. I want to give a shout out to California. I want to give a shout out to Phoenix. We went everywhere. We talked to many different people, you guys. And so every attorney that I spoke to agreed that Robert's rights were violated in his conviction. It was just a wrongfully conviction. It was an overkill. You know, it's just so much. Like I was talking to you guys yesterday, I apologize for yesterday. You know, I was on the road, so you know, of course I'm gonna be going in and out, because when you're going through these different little small towns, the signal is terrible. But I got some good feedback on so many different levels, and the attorneys that I spoke to, they were like, hey, they wouldn't think if an attorney look at it, they wouldn't turn it down because they said, they see a lot of, kinks and violations in Robert's during his trial. So let's just hope for the best. So for the people that don't know who she is and how she represented Bill Cosby, I'm gonna play this so you guys can just speed up and have some knowledge on this lady's skills, because she was really ready. So I know she will look at the information and point out everything. Um, Even speaking to the attorneys in different states, they spoke on, you know, about the witnesses, who they had as witnesses. So let's take, for example, we have the Clarys. They spoke on signing a consent form for Azriel to go with a lady, Valerie Payton. And so the paperwork that was floating around the internet, and even Gail King is showing a piece of paper, but then the attorneys for the prosecutors shows documentation of something where it was notarized. So the question on that: where was Valerie Payton? Juice. Where was Juice? Where was the person that notarized these documents? They had people to be there to notarize that spoke on filling out the papers for the marriage license. So why they didn't pull that up? Okay. So another question: where were the officers that Azriel spoke on coming to the hotel? Where were the surveillance cameras? Everything that we experienced and hearing in the trial with Robert Sylvester Kelly in New York, you had a bunch of bad act witnesses. You had people just on there just speaking. You didn't have no concrete evidence. You just had people coming up there speaking lies, and that was coerced by the prosecutor. So they want to convict Robert of saying he coerced some people. So we need to go in and convict these New York attorneys, because they coerced, you know. So it was just so many different things. And then you go back and look at all the filings that Judge Anne denied. I don't think so. I don't think they can bring up new evidence in appeal. And from my research and talking to other people, you cannot. But you know what to bring up. But if you're talking about the same thing, you can bring up, things that speak on that same topic. But you can't bring no new evidence into the appeal. But hopefully, we're not even trying to get a retrial. We're trying to get a overturn. We're trying to get an overturn on his conviction, you know. And I'm pretty sure that the prosecutors, they don't want to go through this whole thing over and over again. So it was just like you see a whole lot of Kingston is, even with the conversation with Azriel and her mother. Why not have the conversation? If you're going to put the conversation up, put the conversation up. That's one person having a conversation. Even with letters that they said they found that the Jane Doe's wrote, and who's to say that she wrote this note when she was in the this man's home? She was in his home. She was working with the feds then at that time. So who's to say? No concrete evidence. None. You had a bunch of people getting up there talking. So is your word against the counselor's defense's counselor's word from what the information Robert gave? So it's just a lot of kinks. So like the attorney said, is it's something that they never. It's just they seen crazy cases, but nothing like that. Nothing about how they did Robert's trial. So it's like all the key people. They kept bringing up Lily's name. They kept bringing up Joy's name. They was bringing up Juice's name, and look who they picked as witnesses. I'm back at home now. I'm getting ready to go to work now. It's time for me to go try to make some money. I paid out a bunch of money to get some real information from professionals, and so I'm back at work. So um she's great. I can say that, and I'm just gonna say it because I already know it's female chicks gonna be trying to inbox each other, have a group chat. Talking about there she go, talking about what she knew. This was in the makings way before Robert's trial. So they was working on things in the background. So I ain't gonna even go get into the details of that. But thank God that she decided to jump on um, this, because I know just like the other attorney that I spoke to saw this and they saw a violation with this. So I'm pretty sure that's why she jumped on it. Um, and I don't think that she would have gotten into it because it was too late to get into it. So let's just pray for the best and hope the people don't bother her. I hope you guys leave her alone. Let her do what she needs to do. She knows exactly what she's doing. But you do, and did you know? Just tell him, don't hate you, hate your sources. Yeah, that's why I was saying, like, cause like when I say something, cause you already know, Mr. J, I tell you and I tell another person, so I can have witnesses or at least somebody to know what I'm talking about before it even happens. So I don't worry about those people, in their private group chats and all that kind of stuff. I have one person send her stuff. No, she know what she's doing. Everybody, it's overwhelming, and you could tell when those attorneys and their secretaries are agitated, because the people that actually needs to call and needs to give some details, they're like overwhelmed and frustrated because you have all these people just calling talking about he say she say, and okay, this person said this, but you don't have the concrete information to give to these people. So leave them alone talking about what somebody said. They want information, they want evidence, they want facts. They don't want you calling them like, well, I know you can talk to such and such. They say they know everything about Robert and things like that. They don't want to hear that. That's unknowing. That's overwhelming. I mean, I'm just saying, if for a fact this is overwhelming. And let them do their job. They are professionals, but I'm gonna go ahead and replay this video that I did a while back, breaking down Miss Jennifer's opening arguments and stuff, because I was applying her. I was like, you know what, this is how you do it. You be ready for the justice, you be ready for the prosecutors, you be ready to break it all down. And so I'm gonna let y'all see how she do the thing. She's doing her thing. So this probably was for the best. See how they put this stuff out there, see how the prosecutors putting things out there. A lot of stuff she spoke on with Bill was very familiar, and I did my breakdown talking about what was going on with Robert's case before the trial happened. And so we ourselves and we're not lawyers. We don't know a lot about the law. We have been learning about the law since Robert's trial, since his case came forth. And we need to continue to learn about the law, continue to learn about what's going on here, what laws we need to change. Because if we don't find out about these laws and then something happens, then you're like, dang, I didn't know about this right here. So you mean this can happen to me if that, if this, so I'm gonna get a felony for this. Y'all, it's important to learn the law. What's up, Houston? What's up, Houston? If you keeping up, Raven, if you're keeping up with what's going on here in Texas, you can see what they're doing to Sylvester Turner, Mayor Turner. And so, Sylvester Turner is a Democrat, and he's a great person, and he will not back down. He's not going to bite his tongue for no one. And if the government is wrong, he is going to say what he needs to say. So now they're trying to come up with some stuff saying that he used somebody he knows to get a contract to I think it's affordable housing or something like that. So now they're trying to mess with him. They trying to take him down just like they did those the mayor, the governor of Cuomo in New York. And this is what they do. And if we don't get out there and try to work on these things like it's supposed to be, because yeah, YouTube can put out some information, but that we need to go and speak to people in that field. We need to go and speak to politicians. We need to let our voices be heard at the Capitol, just like them damn Trump supporters. They made noise. And it was different organizations formed together. Nobody took credit, you know. Even though it went left, you had a bunch of damn hillbillies. And when the ones that was arrested, and I was like, I guarantee you they from the South. And I'd be damn deep in the South of Arkansas, one of them, the home of the KKK. So we have to hit it where it's important. We have to hit this the politicians, the governors, the lawmakers. We have to express how we feel about these laws. A damn hillbilly, hell, I knew he was a damn hillbilly. My client and I was going over some stuff, and then the news popped up, and they said they arrested the guy, and you can hear him talk when he put his feet on Nancy Pelosi thing, and they said he pissed in the damn corner of the woman place. I said, yes, baby, I guarantee you that damn hillbilly's from Arkansas. And I be damn, he was from Arkansas. Found out where he was from. So I sent the information to my client. I said, did I tell you that damn hillbilly? Shit, when you get a mixture, when you bring the South into something, baby, they believe in something, they gonna let you know. Okay? They gonna let you know. So yes, it's good to hit these professionals, honey. Yes, baby. Cause honey, a woman, somebody texted me yesterday, and you texted me, and I'm like, wait a minute. I said you need to call me so I can talk to you, cause I want to know what the hell you want me to vote. Don't tell me to vote for you, and I don't know who you are. I don't see you out here in the community. I don't see you, making a difference in anything. So why should I vote for you? You need to let me know why I need to vote for you and show me some evidence. So she was like, matter of fact, because honey, I ain't gonna lie on anything I do. Cause she just like texted me. I bet she said, oh my God, what I get myself into. Let me see. Because I know is okay. So her name is Christina. She with the NAACP Legal Defense Fund. Okay, she talked about the election. She said she was talking about it's important and what ballot she gonna be on. It's a statewide constitutional amendment, and the election impact us all, and the all the way down to our neighborhoods with school boards, race, and all. I already know this. I already know how important it is to get out there and vote. So matter of fact, we can vote today, because I'm gonna try to hurry up and do what I need to do so I can get my ass and go vote real quick down the street. I already looked at all the information, what's important for the schools and stuff like that. I write down everything. I write down the people. And, I look at, who's going to be doing this and who's going to be doing that, who needs to run the board, school board, who needs to be over the school districts and things like that. So I'm looking, I'm like, you ain't did shit. You ain't did shit. You ain't did. And then you still in here and stuff still not done for these low performing schools in these bad neighborhoods. So the hell with you. So I put on there, I said, hey, I said, you can call me and tell me about yourself. I said, don't just text and tell me to vote for you. I know all about the importance of neighborhoods and schools, but I want to know what you're going to bring to the schools and to the community. So she said, this app is used for texting, doesn't let me talk, let me take calls. I can answer questions over text, or you can find more details about what's to bring here. So she gave me a link. I don't want no link. I want to talk to your sister. So I went back in. I said, I want to do a Zoom call with you personally. I want to look into your eyes so I can talk to you. I need you to give me some information, and point out what you have done for the community, the schools. I need a resume. You know what I'm saying? Don't come and tell me who to vote for. If you can't put that resume package down on me, we ain't got no talk. If you can't take the time, if you can take the time to push that text button to tell me that, you can take the little of your time to talk to me, and maybe I can help you. Maybe I could tell other people about you. Maybe I could tell, everybody your resume and who you are. You see? Yes, baby, they full of it, baby, because they got the wrong one. I ain't about that. I need some facts. So let's get on over here to this right here and let y'all reminisce.
Good morning. In this case, the felon was convicted of aggravated indecent assault stemming from an incident that occurred in 2004. Prior to trial, the felon moved to dismiss charges, claiming that the prosecution had granted him immunity from criminal liability. The motion was denied. During trial, the Commonwealth introduced 5 witnesses under evidentiary rule 404B to testify regarding their accusations of sexual assault against the appellant for purposes of establishing the appellant's common scheme or plan. The issues before the court are whether, 1, the testimony of the 5 witnesses regarding their respective accusations was admissible evidence under Rule 404B, and secondly, whether there was a binding agreement between appellant and the Montgomery County District Attorney that would result in immunity from criminal prosecution. With that, we'll proceed with the appellant.
Good morning, and may it please the court. In our system of justice, a defendant must be tried for what he did and not who he is. And yet the prosecution has made no secret of the fact that it intended to indict Mr. Cosby's entire life. After failing to secure a conviction after Mr. Cosby's first trial, the prosecution shifted strategy, laying waste to the presumption of innocence and telling the jury that Mr. Cosby's claim of defense could not be believed because, quote, he had done this so many times before. The prosecution forced Mr. Cosby to defend not only the charged offense, but 5 mini trials and vague accusations from countless Jane Does dating back to the 1970s. And while the public and the media were free to judge Mr. Cosby's guilt based on those factors, his criminal jury was not. And perhaps a limiting instruction served its purpose at Mr. Cosby's first trial, but there can be no confidence that it did its job at the second, where the jury was bombarded with prior bad act evidence. Indeed, half of the prosecution witnesses testified in connection with uncharged 404B allegations. Some of the allegations, the most damning ones, came from a deposition that should not have been admitted in the first instance on account of an agreement with the Montgomery County District Attorney not to prosecute Mr. Cosby, a promise on which he relied to his grave detriment.
So they both from the Montgomery County did.
As argued in our briefs, none of the prior bad act evidence served a legitimate non-propensity purpose. But that aside, consensus surely must be reached that Mr. Cosby suffered unquantifiable prejudice where the PBA evidence or the prior bad act evidence overwhelmed his second trial, converting it from a trial on a single offense to a trial of his character. With that, I would entertain any questions from the court.
Great opening statement, Jennifer. This is Bill Cosby's counselor, and Jennifer did a great job opening up, with her opening argument, letting them know from A to Z what they are asking for. And that was great. So I think Jennifer did a great job, on explaining to them what they want. And also she was ready for the judge's questions as well. She was well prepared. So I'm going to move on to the next one. So I'm going to say bravo to you, Jennifer.
Counsel, this is Counsel Justice Doherty speaking. Let me just zero in on the civil deposition. Even taking into consideration and finding is true that he, Mr. Cosby, your client, did not believe that he was to be prosecuted for the events involving Ms. Constantine. Tell me, when confronted with a question plausibly implicating criminal conduct, in any deposition, an individual has an affirmative duty to invoke their Fifth Amendment regarding other issues or potential other criminal conduct. Why was that not done by counsel for Mr. Cosby or Mr. Cosby himself? Justice
Doherty, his question was like the Fifth Amendment, like, okay, why he didn't do the, plead the Fifth, just like Jim Derrick Greasy, Jim Derrick Greasy, I'm sorry, Jim Derrick Gaddis, he plead the Fifth. And I was like, okay, damn, Jim, you plead the Fifth just to protect your sources so you can have some stuff to write, some articles, to have some great articles. I don't want to give up my sources. So I'm going to plead the Fifth because I do not care about these Black women. But he's out here in the public saying that he care about the Black women. They use this statement that they don't care about the Black women. But if Jim Derrick Gaddis cared about the Black woman, he would have testified. He wouldn't have pleaded the Fifth. That's an example of pleading the Fifth, you guys. And see, Jim Derrick Gaddis, he didn't want, he only write about Robert. That's his occupation, you guys. Just to write about Robert, R.kelly. That's his livelihood to write about him. So he plead the Fifth because I do not want to up these people that's in Robert's camp, that's giving me all the tea and adding a little lies to it as well. So, I'm going to plead the Fifth, but I'm going to, I need to get back out there into that light. I need to get back in the spotlight because I'm dying out. Because, Robert, he's chilling and minding his own business. So, he done laid off all my sources and stuff. So now I have to use this like, I don't care. They don't care about the Black women. I don't even care about the Black women. Because I plead the Fifth. So I wasn't thinking about no justice. I was only thinking about, my livelihood, because this is my occupation, running behind the brand R.kelly. You feel me?
Linked to the willingness to give a civil deposition, which we know this in part from looking at the press release, which demonstrated that not only did the district attorney at the time, Bruce Castor, decline to prosecute, But he mentions in the press release that there was going to be ongoing civil litigation. So, and you also can look at Mr. Schmidt's testimony, who's testified that it was our understanding, it was our belief that the promise not to prosecute would be honored so long as Mr. Cosby agreed to sit for this deposition and give testimony and not invoke his Fifth Amendment right, which he did, again, to his detriment. I think the fact that Mr. Cosby actually answered questions for 4 days, and I think it speaks to the court's point that this is evidence in and of itself that he relied on this representation. No one would sit for a deposition and not invoke their Fifth Amendment right, guilty or innocent, if there was the possibility of criminal prosecution looming over your head. So the fact that he did leads to the only reasonable inference that he believed that in order to not be prosecuted, this was part of the agreement that he complied with. And as a result, to the extent that the prosecution wanted to use the deposition testimony, once they decided to prosecute him, that deposition testimony should have been off the table at a minimum.
Counsel, Justice Baer, at the first trial, and I don't think it's in our record, but it is properly before us, was there any prior bad act testimony?
There was one prior bad act witness who testified at the first trial, correct.
And of course, you didn't take an appeal because that was not a conviction.
That's right, Your Honor.
I understand your argument. I tend to agree that this evidence was extraordinarily prejudicial to your client. But there's a trial court discretion component here. In your view, if the trial court had allowed one again, would that have been an abuse of discretion? Or if the trial court allowed two? And where do we as an appellate court draw a line between abuse of discretion and a discretionary call, which perhaps we would have not made, but which we're not powerful, we don't have the power to overrule?
Yes, understood, Your Honor. Our position is the trial court abused its discretion for two reasons. One, because not even one prior bad act witness served a non-propensity purpose, but also because the admission of 5 prior bad act witnesses was unduly prejudicial to the point that no limiting instruction could have cured it, and that these 5 discrete allegations from 15 to 22 years ago had such minimal probative value as compared to the danger of unfair prejudice that it seems clear that the court did not exercise discretion in allowing 5. So it's twofold. Our position is that there was no theory of admissibility that was for a non-propensity purpose. But even if this court were to disagree with that, at the end of the day, 5 witnesses plus all of this vague testimony about quaaludes and Jane Does that were just exploited to the hilt during the closing arguments that frankly were just contorted from the deposition testimony in the first place, put Mr. Cosby in a position where he had no shot. The presumption of innocence just didn't exist for him at that point. And so I think the court abused its discretion in both of those ways.
Thank you.
Sounds very familiar, doesn't it? Court abuse, presumptions of innocence, and prior bad act character witnesses that we have going on here. Also dealing with Robert Sylvester Kelly's case, we have a Lisa Van Allen, we have a Geronda Johnson Pace. There is something in the past, an old trial that he was found innocent, and so they're bringing back Landfair family. So I feel even with the DA in New York for Robert's case, they are actually abusing the system, the court system, even not giving out the evidence and, discovery. They're not giving Robert's counselor this discovery. They're trying to wait till the last minute. So to me, it's just like abuse of power. And so hopefully Bill wins the case and that we can open a door to look into how things are handled in the courts. So let's continue on to the next statement.
Council, this is Justice Donahue.
Good morning.
Good morning. Since you are not going to have time for rebuttal,
Yes.
I would like you to, for me, spend a little bit of time talking about why the evidence that was offered through these prior bad act witnesses did not go to establish a common plan or scheme or a signature crime, which is what I understand their purported use was.
Yes, Your Honor. So at the outset, I would say the common plan is an inapt theory of admissibility here for two reasons. One, because the prior bad act evidence was not part of a single overarching plan, which I think the prosecution concedes. It also was inapt because identity was not a disputed fact in this case. And the overwhelming authority from this Commonwealth and across the country is that signature-like prior bad acts, also known as modus operandi evidence, is relevant to prove identity. In fact, the test in this Commonwealth is that it must be so nearly identical to be the handiwork of the same perpetrator. But when identity is not in dispute, the evidence simply registers with the jury as propensity evidence. To put it very simply, where identity is a dispute, a modus operandi may be perfectly proper. Where identity is not in dispute, it just amounts to propensity evidence. And make no mistake about it, that is what the prosecution is asking this court to do, is sanction propensity evidence. And simply because the prosecution can shoehorn prior bad act evidence into some exception, it does not make it admissible, since it may not bear on a matter at issue in the case. But with that said, if any members of the court disagree with that analysis, and that may be the case, even if this court believes that the signature crime approach is the appropriate approach to this case and a proper theory of admissibility, the prosecution still does not prevail here because the prior bad acts were general in nature insofar as they involved sexual misconduct of some type and the use of an intoxicant. They were not nearly identical as to the charged offense, at least any more nearly identical than they would be to, frankly, almost the majority of acquaintance assaults or date rape situations, where we know that intoxicants almost invariably play a role in those types of assaults. But if you want to get more granular about it, in this case, we have prior allegations, again, 15, 22 years old prior allegations that involve a number of distinctions from the charged offense. I think one of the most astounding ones is the nature of the relationship. You cannot compare the relationship that Mr. Cosby allegedly had with these 5 other women that he did with the complainant. This was an 18-month relationship. This was a relationship that, at least by her own testimony, was built on friendship. They exchanged gifts. They spoke regularly. This notion that he was mentoring her, well, I mean, anybody who comes in contact with Bill Cosby is going to sort of, given who he is, could perceive that he would be a person who's wise and would be able to give you advice. But this is not the scenario where he sought her out or she sought him out for some to advance her acting career or a modeling career. This was a chance encounter. He brought her into his inner circle as a friend, introduced her to people he knew. He traveled to places with her, where New York, Connecticut. So the nature of this relationship was very different. In the 5 prior bad act cases, one woman had not even been invited to Mr. Cosby's home. She just came with a friend, and she was not an actress, and she didn't. This was just a woman that showed up to come socialize with Mr. Cosby with her friend. The other women had met him once or twice.
That part there sound like that damn Geronda Johnson Pace, the damn psycho from hell, psycho super fan from hell.
So again, the nature of the relationship, I think, is a marked difference between the prior bad acts We also have very different sexual type of contact. One of the women, Ms. Lublin, testified that she doesn't recall any sexual contact other than some bizarre behavior where he allegedly stroked her hair. And some women describe, intercourse where other women describe that there was something that didn't involve penetration. So the sexual acts themselves were very different. The nature of the intoxicant was different. In some cases, like Ms. Baker-Kinney, she said, I took the Quaalude. He offered a Quaalude to me, I took it. There's no evidence.
I'm gonna continue, but can I say something real quick? I know a lot of stuff has happened in Robert's case. A lot of things, happened in his case, you guys. Let's start keeping. Let's just stay positive and stop bringing that negative stuff. Let her do what she does. Just pray that God block all demonic spirits from this and stuff, because when you speak that, that's what it be. So I'm not even like, oh, I hope she don't go in and do like this person. Oh, I hope she don't get paid off and stuff like that. When y'all start bringing that kind of energy in, it's just a bad look. Just like at the trial, as a supporter, you will hope that they will play his spiritual things, and just play spiritual his stuff, showing people that it's not only 12 play and ignition and bumping the grind, because that's all they knew. But if you would have shown that this man has great music and he speak helping women and loving women and things like that, and let them see this person, that would have helped. If the reporters was out, they were like, oh, that's his song, and things like that. So let's keep that great energy. Let's keep that great energy. Let Robert worry about them funds, who got them funds and stuff like that. I'm not gonna sit here and worry about how she got on there. She is on there. I am just grateful for that. That is not my business to be like, how you get paid, girl, who paid you, and stuff like that. It's done. It didn't come from the dollar from the king, I can tell you that. But it has been done. It's been worked on for a while. They've been preparing for this for a while. It took multiple people to try to get this together, and it is done. So let's embrace, make this something great. Because when you pouring salt on something that's supposed to be sugar, let's just embrace it. And that's all I'm saying, because I'm like, I wasn't looking, I'm listening to her, and then I look over, I'm like, oh, y'all, come on. It doesn't matter. So at the same time, sweetheart, don't even worry about that money. That's far from what Robert is worried about right now. Because Robert cannot do anything with what's going on out here right now. Anyway, let's just take one step at a time. Let's just take one step at a time, because we get this done, then we got another hurdle to jump over. Then once he out, he can handle all these damn people that stole from him and did what they did. So I'm just gonna take this for something, what, God, we got some experienced people that we were talking about last night, getting professionals, taking the time to know who you dealing with, and stuff like that. Well, you can't do that, baby. Hell, you can't get those refunds back from no attorney. That's just like some of these damn, like when y'all take y'all ass to them damn hair supply stores, do them damn Japanese give y'all stuff back and they done gave y'all some messed up products or some messed up damn weaves and stuff, and they promise you this gonna work, and you take that stuff back and say, hell, I need a damn refund. They be telling you, there's a no refund. There's a no refund. Get out of here. After they get your money, they kick you to hell. They get your black ass up out of here, because I ain't got nothing for you. You just spent your money. You came in here. You didn't take the time to read our policy. You just got this stuff. Now you're talking about give me a refund. It don't work that way, baby. We're not with no attorney. That's why you have to do your research on who you're going to represent you. And that's why you have to have a say-so into what they're doing for you. And if you feel like you're not getting they're not doing the job for you, it is your job, because you hired them to do something for you, to speak up and say, listen, I'm not feeling good about this. I think y'all need to do a little more. I think y'all need to, we already know Robert's situation. So hopefully somebody step in to be right there by him. Just I think I was talking to somebody last night about it after I got off live. You remember when Judge Anne, I can't recall that what they call those attorneys, but she let this lady come in and talk to Robert about keeping what's her name, Lord, keeping the female defense attorney, Nicole. So she had somebody to advise him and explain to him what and and things like that. So Robert needs somebody like that as well. But this lady did a great job. She hung in there with Mr. Bill Cosby. She did a thorough research. She's one of those, I can call her one of them newcomers into the law. She know the new laws. She's experienced with knowing the rights and civil rights and stuff. She worked with civil rights activists and different things like that. She know the law when it comes down to violating civil rights. So we're going to take that like that. We're going to take her resume as it is. We know Nicole's resume. Nicole worked for the prosecutors. Nicole convicted a whole lot of people she worked with on sexual assaults and things like that. So, you can give her the eye, but look at this woman's resume. She did a great job. I just want to step in and say that, y'all. I just want to see some clapping, some praying, and stuff like that. We got to bring some positivity into this atmosphere. We done been through 2 years of hell. And let's just keep that hell out of this right here. Don't bring the hell into this woman here. I'm just putting all positive spirits into this lady's work. And when she do it, she's gonna do it hard. She's gonna work hard because she has a reputation to maintain. And I don't think that woman gonna go half-stepping, because she know this was a big case. It was a big boo-boo, and that this woman see all the injustice in this man's trial and everything that went forward, that's going forward. She see what's trying to go on, and she let that damn side judge sidebar, if you don't give him a pretrial, I'm coming at you. She already told him. So let's just let's go with the flow.
Whatsoever that anybody else was given a quaalude, even among the other 4 prior bad act witnesses is in the charged offense. For as much as quaaludes played a role in this case, from the prosecution's perspective, they will concede they have no evidence that Mr. Cosby gave Ms. Constant a quaalude, or anybody else, frankly. The only person who speaks about a quaalude is Ms. Baker Kinney, who said, he offered me one and I took one. So, yes.
This is Justice Todd.
Good morning.
Good morning. Let's assume we accept your argument on prior bad acts, that it was error to introduce it. Could you address the harmless error question? Could this possibly have been harmless error?
It could not have been harmless error, and I think we need only look at the first trial to get our answer to that. It is clear that the prosecution wanted and needed propensity evidence, but they had no right to it. You don't get to make up for weaknesses in your case by bombarding each jury with rank propensity evidence. That's not fair. And frankly, the prosecution's case, the evidence was ample. They didn't need this evidence. They had the.
Okay. All right, you guys, I do have to go to work. I'm gonna pause that video. We're gonna come back with part 2 when I get off. And we're gonna talk about some more things that I saved up. We're going to talk about the Roberts Grammys. They have no right to take his damn Grammys. I'm gonna pop up something that just popped up last night with Harvey Weinstein. So I'm gonna be talking some mess because you better not touch his damn Grammys. Okay, so you guys, I have to work. I got to make money, honey, because I'm self-employed. And when I'm not at work, I was off for 2 weeks, running all over the place, talking to professionals and stuff. And when I'm not working, I still got overhead. So I got to get my black ass to work. Okay. So we're gonna do a part 2. I'm gonna put part 2 on this one right here. I'm gonna edit it real quick. I'm gonna put part 2, part 1 on here, and we're gonna come back. Y'all come back with your conviction. So y'all write down, what you want to talk about with this. Go back and look at what y'all what she was talking about. We're gonna talk about this stuff. What wasn't done right, in Robert's trial and stuff like that. Damn, they said I'm being over. Okay, Jennifer. Civil rights term. Let me take that off. Let me take civil rights down real quick, because it won't let me say part 1. I'm gonna take civil rights attorney down. Oh Lord, these folks up talking about the podcast. Let's cancel then. I'll go into my little thing and we'll change. But y'all, what blessing to y'all. You know what? All we gonna, like I was telling y'all yesterday, in order for a change, okay, in order to get something done, and you in there, you having a meeting, and everybody in an agreement of what we need to do. And then you got Shanae coming in there being hood rat, disturbing and acting a fool. And then you have all these group of people just sitting here wanting change. And then you call her ass out. She gonna either sit her little nay ass down and listen and get some information and work with the group, or she can TYA. This is the time where we need when we need to be trying to do what we said we came here to do. And it's time to start walking a fine line. And I'm letting y'all know now. I wasted some days and some months with dealing with BS, responding to BS, and I'm not doing it anymore. I'm on the real for real. I done went to the light. God that took me out there to the light. He done took me to the light. He done told me. He done told me and gave me my mission, and I'm finna do what I need to do. I'm gonna go the right direction. I'm gonna deal with the right people. I'm gonna surround myself around positive people that's gonna be motivated, people that's not gonna always be talking about drama and stuff like that, because there's no time for that. I don't have time for it. I'm not trying to go back to no hospital, because this time God can be like, you didn't listen, so I ain't bringing you back. I'm not bringing you back. So I'm just trying to keep calm and just deal with things the right way. What I don't know, I want to go seek it out with a professional and things like that. Baby, I understand what you talking about. Walmart, honey. Everybody ain't Walmart, honey. Honey, I do the trip be out shit, honey. This poor baby said they need to give Robert a refund. You know how many people that had attorneys and stuff that messed up, and see how many of them attorneys don't get them a refund. They're gonna let you know, baby, you ain't at Walmart, you ain't at Target, you ain't at Amazon. This is a job. Now hopefully these people will be like, okay, I didn't do this right, and I need to go ahead and do this for this client. I need to go in and step in and be a part of the team, for a lesser pay, because the people gotta work, they gotta get paid. They did it what they could. You know what I'm saying? Because you see, Judge Anne was denying so many things, like even with the expert, the herpes expert. Okay, you can bring them in, but they can't come in and try to debunk what the other expert said. So what the hell I'm bringing a damn paying for an expert and I can't ask a damn expert what I need to ask them for my client? That's another violation. Telling them what they can't do and but allowing the prosecutors to slide in damn more evidence in last minute damn bad act witnesses, and she allowed all that. But every time you look around, she debunk and she stop and she overrule and she I just need to talk to y'all about a break. Y'all think we're gonna have time for a lunch break? What time y'all think we're gonna be finished? And this man in the middle of a damn cross-examine. And you think that was fair to Robert in his defense team? Judge Anne, did you stop the damn prosecutors? No, you sure didn't. And then you acting like you damn attorney. You the referee, the judge, and the damn prosecutor's attorney too. You're working for the damn prosecutors. You asking questions. That's unheard of. It'd have been different if it was a judge trial. It wasn't a judge trial. It was a jury trial. And this Judge Anne did so much violation, I don't even know. So, baby, this female, she said, I'm ready for you, Judge Anne. Now, if we don't have no pre-trial, I got you, sister. That's exactly how she put it. But y'all be blessed. I'll see y'all. Let's see. Damn judge. Y'all need to start saying hashtags judge sidebar, because this is exactly what her ass is. A damn sidebar interfering damn judge. She interfered, telling the damn man what not to do. Don't do that no more. Can you stop yelling? Telling him how he's supposed to run his show. Yeah. This was they. Are you sure we can't send her this video? Okay, we maybe. Well, maybe she knew all of these facts you're speaking. You know what, y'all? I know we be wanting to help. I just ask y'all grown. I'm just a little advice from old Auntie TBD. Auntie TBD just say, you know what? Go back and look at what was done wrong in this situation with the supporters. You see what I'm saying? I'm just saying. Just look back and be like, okay, this and that. And I actually spoke to one of the attorney's secretary, assistant. And I said, this is overwhelming. And this poor child, it just sounded like she was just so overwhelmed. And she was like, this is a lot. This is a lot. And I said, I know his supporters not making it in the easy. She's like, she just took a deep breath. She said, be honest with you, no. She said, but they have so much information, and so I'm just telling you guys, just think about it. Just sit back and just think about it. I know we want to do everything we can to assist. Just think about what wasn't done right. We were sharing important information among each other. We weren't trying to, make noise and get it out there on the news, on these platforms, and things like that. I was a set of judge, jury, prosecutor. We'll see, baby, because that's one thing that will come out. They can come out and find so many different things. I think I spoke to somebody yesterday about it. Judge Anne, during these hearings, she tried to make sure that matter of fact, Mr. J, can you type it in there what we talked about, what Judge Anne said? She want to make sure that they don't make any mistakes to get a mistrial. So you was doing everything in your power. So what you mean? Because to me, it sounded like, I want to make sure this is signed and sealed. I want to make sure y'all don't make any mistakes. She even told the prosecutors, okay, can y'all give these people this discovery? Do y'all know about this this law, this rule? And that's when they don't give all the discovery, and they find out later on that they can overturn his conviction. So she was working with those prosecutors, letting them know, look, make sure you give them everything. And so then you say, well, yeah, I'm gonna allow them to bring this evidence in, even though it wasn't in the discovery. But y'all, you didn't tell them what you told the prosecutors. You didn't say, well, I can bring it in, but if you want to argue this right here, this is your time. The defense team to argue this new stuff that they bringing in at the last minute. She didn't school them on that, but she was working with those prosecutors, telling them what to do and how to do it, and asking questions for them. You know, I want this to come out right, so I'm gonna ask it for y'all. You see what I'm saying? She said, okay, yep, to make sure there was no grounds for mistrial or an appeal. So when Judge Anne said that, and there's a lot of stuff that I talked about, and I was trying to get all the matter of fact, I sent for all the hearing his hearings transcripts. And so I was telling the attorney about something that she said, and I can't quote every word because it's not in front of me, but I do remember, because I came on here and I was talking mess about it. I said this woman here just basically saying, I'm not gonna do this because you according to the prosecutor, saying you bribe some them land fares. So no, I'm not going to allow you to get out because you bribing people. Now, what happened to trial? Now we go to trial. Now, and this wasn't evidence, but you took it, and you took everything that these people are saying, and you believed it as a judge. You didn't believe in his due process. You violated Judge Sidebar. You violated this man's due process because you accepted everything that these prosecutors saying, even not looking at his past record. He never fled. He never ran anywhere or anything like that. And like I was telling you guys, they know exactly the conversation that Robert had with Don Russell. They know the exact conversation Robert had with Don Russell's mama. They know all these conversations with everybody. So if Robert was this person that was demanding thing, where was the evidence? Why y'all had to bring down hearsayers on that damn witness stand to test a damn lie? She said a lot of things. And that's why I said all they got to do is pull up them down his hearing and listen to everything that woman Sidebar said. Thank you. That's what I'm saying. That's okay. Thank you. See, you got that young brain. I got too much of a brain. That's the see that I'm looking for that transcript, because that's exactly what she was saying. I said, what the hell you mean? I said, you take away this man damn due process. You got people that done killed people, killed kids, got a bond. Even the man that killed Houston baby Malia got bond. He had a chance to bond. Okay? What the hell going on here? Yes, he been violated. And every attorney I spoke to agreed on. But I'm gonna see y'all later on today. I think everybody goes on to Choke No Joke page. Y'all have found y'all new hangout house, so I'm gonna try to see what time the band come on, and then try to finish what I was doing here later on, because I gotta feed myself, honey. I got to eat. So y'all be blessed. See y'all later on. Write down your notes and everything. So maybe, you know, I can get y'all to come up and just speak on how y'all feel about what the judge did and how the trial went and how the prosecutors did what they did and what the defense didn't do. Y'all feel that the defense didn't do, what witness should have came up there to debunk whatever. So, you know, just write it down. I need y'all to write it down and make some sense. That when you come up here, you know, we got to start, you know, writing our stuff down, our information down, and, you know, make it make sense to the people that still on the other side, because we're trying to bring them on over here to the damn light. So I'll see y'all this afternoon. Be blessed. I'm gonna bring some of my people up here on this panel, let them talk too. We gotta break this down, you know. So be blessed. Thank you for tuning in. Thank you to Maz. Thank you to all the viewers and the subscribers for coming in, joining me, you know, for part 1. And we'll do part 2 this afternoon. Be grateful, you guys. Be grateful.